So because it's nearly 5 past, what I'm going to do is I'll do the antitrust stuff, and then I'll check myself up. I'm in an airport, for those who just dialed in. My apologies for the background noise. So this is a third of our 3 webinars with OFE. We're going to have Kieran once again, this time on the Product Liability Directive. Previously, we've had a look at the Federal Resiliency Act, and we had a look at the OFE Act. So this completes the third item that was on people's radar. Now, before we get started, the antitrust policy notice as usual. You'll find the full antitrust policy on the website. And if you're from a member company, you can ask questions of our counsel, Andy Upthegrove. It'll be, of course, Kieran's thing to dig into the Product Liability Directive. But in essence, what I've got here is a brief overview that this thing existed previously and is being updated. And this is the first time it's changing in about 40 years, it seems. So it's quite an interesting situation to have product liability revisited in the European Union. Our speaker, Kieran, has been working in the space of EU policy and dealing with all the types of things with the Commission and our Parliament and NGOs for as long as I remember, which is a long time indeed. We're not young. And he has very generously run through all these different webinars for us, engaging with topics that companies around the world have talked about, considered, and quite frankly, I think needed guidance on. There's an awful lot of blog posts and excitement on the internet about topics like the Cyber Resiliency Act and this AI Act and the Product Liability Directive. What's less clear is how the real situation impacts companies, away from the blogs, away from the headlines, what's really going on. And that's what we'll find out. Now, Kieran, I'm just going to dial into the Project Control Center and make you co-host, so you'll have full control over this meeting. And of course, I'll be there in the background as well to assist as useful. As we proceed today, I do want to stress that typically for our webinars, you are encouraged to ask questions and engage as you go. And of course, you can do that either by unmuting yourself or by typing something into the chat. If we don't get to you straight away, we'll get to you before the end of the meeting. Enough from me. I'll hand over to Kieran to share his screen and to actually deliver something exciting and useful in this webinar as opposed to my prelude.
What I'm going to try and do is look at the combination here of the Product Liability Directive, liability in general, and the situation for free and open source software. So the first thing is why I'm giving this particular presentation instead of somebody else and instead of a different topic. A lot of people are interested in this topic. However, we don't have many people who are specialists in the topic of product liability. And this is similar to what we faced with the Cyber Resilience Act. We had to get active quite quickly on a topic which was quite unfamiliar, that was market regulation. And so our legal and policy specialists are often very well educated and experienced in the topics of copyright and patents and other legal topics. However, market regulation was quite new. I think product liability then was even more obscure because at least the Cyber Resilience Act talked about cybersecurity, and we definitely have cybersecurity experts, and they were able to help the legal and policy people to understand the technical and the development and dynamics of that domain. Product liability is a bit more complicated. We certainly have lawyers, and there are lawyers who give presentations about liability, and there are lawyers who are expert in what the law says and the case law that exists on product liability. However, this is really only one part of the discussion, and the case law generally doesn't take software into account. A lot of the case law is about physical products, and then people are trying to infer what this might or could or does mean for software. So the lawyers that we have are very useful, but that's only one element. We then have to add in the development methodologies that we have and other economic and legal topics. Which is to say that if people are tuning in hoping that I will summarize the PLD as a topic whereby you only have to think about it if you're doing X, Y, and Z, and that then you can minimize your responsibility by doing A, B, and C. And I added the word you only have to think about it if you're doing X, Y, and Z, because if people are looking for that information, they're probably hoping to minimize their exposure or their risk. Unfortunately, that is a question that can't yet be answered, and I'll go into the details of why that is currently the case. So the Product Liability Directive, just a small clarification, the correct full name is the Directive on the Liability for Defective Products. So just if you go searching for it and find these two names being used, don't worry, there are not two different texts. So I put the code there on the screen. And this text was also published more or less at the same time as the Cyber Resilience Act. So the concerns that we have for the Product Liability Directive, I think, can be summarized in three topics. There's liability, there's divergence with other texts, and then there's the definitions of free and open source software. So I don't expect anyone to read the text that I'm displaying on the screen there. I'll break it up now. But this is just the main text in the original proposal, which discusses free and open source software. And so I'm putting this on the screen because this illustrates the three topics that I'm going to discuss during the talk. So the texts are mostly the same. The left is the Product Liability Directive, and the right is the Cyber Resilience Act. So they both contain an exemption for free and open source software, and it justifies the exemption by saying that we don't want to prevent innovation or research. And so it creates the exemption then for free and open source software. However, both contain this criteria that the exemption only applies when the development or supply is outside of the course of commercial activity. So it then follows a definition of free and open source software, which is pretty much the same. And then some clarifications about what does it mean for software to be in or outside the course of commercial activity. And we'll come back to that again later in the presentation, and then repeatedly also in the next few years. So the concerns here, the main one that we want to discuss is liability, but I want to get the other two out of the way first. So I'm going to talk about divergence and definitions first, and then come back to liability. Divergence is really important because what we're trying to avoid is a situation where we have texts that create obligations and they apply to overlapping but not identical sets of software. So if we can have an identical scope for regulations such as the Cyber Resilience Act and the Product Liability Directive, then we have a situation where some software will be covered by these two and some software will not be covered. If, however, there are different definitions of software, of commerciality, of free and open source software, then we would end up with a situation where some software is covered by the CRA and the PLD, some is covered by just the CRA, some is covered by just the PLD, or some is covered by neither. And so this already makes the complexity more difficult to deal with just by having scopes that are not identical. And the second problem is that if we have identical scope, then when you have case law for one text, you can then apply that to the other text. If we have different scopes for each, then a court case which explains the scope of one text would not apply to the other text. And so it makes it more difficult to get clarification through the courts and after the legislation is finished. So that's divergence. And I would just add, we're trying to avoid divergence between texts in the European Union, but we're also hoping to avoid divergence between the laws that exist in different parts of the world. So if other parts of the world are going to also create product liability regulations, then it would be beneficial for the free and open source software ecosystem if these laws were as similar as possible, so that when people are working on compliance that will be useful in a certain region, then that work should also be valid and useful in a different region. So the more differences we have between the different regions, the more complicated it will be for people to work on compliance. So as much as possible, we want to encourage harmonization of scopes and terminology. The second topic is the definition of free and open source software. And so this has been quite interesting in the past 12 months because it has been defined in 4 very large pieces of regulation in the European Union. So the 4 are the AI Act, the Cyber Resilience Act, the Product Liability Directive, and also the Interoperable Europe Act. So it's interesting then to look at the differences. The AI Act, for example, has this text here, which contains a definition in 6 words to run, copy, distribute, study, change, and improve. And so if we look at this and we wonder, is that the same as our definitions of free and open source software? Then one way of evaluating would be to look at our definitions. And we can find, for example, on the FSF's page where they have their definition of free software, there is literally the text run, copy, distribute, study, change, and improve. So in that sense, it's the exact same as the definitions we've been using. A second text, then, the Cyber Resilience Act, also contains a definition, and they use the more well-known 4 freedoms definition for what is free and open source software. Then we have our topic of today is the Product Liability Directive. And here, once again, we can see the 4 freedoms are there: the freedom to access, use, modify, and then redistribute, modified or unmodified. So that once again, the definitions are staying close to what we expect. And then we also have the Interoperable Europe Act, and the wording here, once again, we have the freedom to use, to study, to share, and to modify. So far, the definitions are all very similar to each other. However, they are different, which may be a little bit unfortunate. They're similar to each other, and they're similar to what we've always used in the free and open source software ecosystem. However, the definition that was published by, for example, the Free Software Foundation is a small number of requirements of the 4 freedoms, but they also have published, and they've been doing this for almost 40 years, a guideline for how to interpret these words, and also then a set of decisions and explanations for how they reached these decisions. So the guideline is in their document, which defines what is free software, and their decisions is the license list, which shows the licenses which have been approved and rejected, and then it gives the reasons for why each license was approved or rejected. So this is important because the definition from FSF allows for certain, they don't use the word conditions, but allows for certain, I'll call them conditions, to be applied to the distribution of the software. And this is reflected then in the Interoperable Europe Act, which says that software must have the 4 freedoms, but also says that the software may be subject to certain conditions, without giving further definition of what these conditions may or may not be. So the comparable part of FSF's definition is that they contain an explanation which says that, for example, a copyleft clause, a clause that says if you redistribute modifications, you have to have the modifications available under the same license. This is a type of condition, and it's clarified that this condition is acceptable, and the reason is that this condition does not conflict with the central freedoms that free software is designed to give you. So this highlights the importance of interpretation, and maybe why interpretation is more important than the actual words of the definition. So the FSF, they published a definition, and then they published a list of accepted and rejected licenses. Then the OSI published a definition as well, and some people were initially concerned that there may be a different interpretation, possibly a broader interpretation by OSI of the definition. However, OSI accepted and rejected the same set of licenses. And so the definitions themselves were different, but the interpretation was harmonized. And so there was no diversion between these two definitions, and the crisis that people were concerned about never happened. So this shows why interpretation is possibly more important than the actual wording itself. Which means we're going to have to work on this in the coming months and years to help governments understand what it means to judge that software is within the scope of their own conditions for the exemption for free and open source software. So that's divergence and definitions. With that, I will come back to the topic of liability. One thing that has to be clarified before we talk about the legal text itself is the licenses that we have used and the clauses that they contain, which always contain a disclaimer of warranty. Even the shortest of all free and open source software licenses contain a disclaimer of warranty. And it's usually a very big wall of text like this, and we love to write it in all caps. The important part maybe is that we say that we provide the software as is without any kind of warranty. This is a necessary thing to protect the developers and the people who are distributing the software. However, we have to understand that law trumps licenses. So our licenses disclaim warranty. However, the law defines what warranty you can and can't disclaim. And so if the law says that you are liable, you can't overrule the law by putting something in your license. So this means the PLD can and does create liability which cannot be disclaimed by our licenses. This is also reflected in some of our licenses. Some of our licenses even explicitly mention that we disclaim warranty as far as legally possible, or we disclaim warranty unless required by applicable law. These words, in many jurisdictions, they don't change anything. In some jurisdictions, they're required as a formality. But the point is that law will always take precedence over what you put in your license. And that's something that means that our licenses don't protect us against the Product Liability Directive. So the next thing then is the word liability it is used in a few different ways. And so this has caused some difficulty in discussing the Product Liability Directive. Because it was published at the same time as the Cyber Resilience Act, people drew parallels, and people decided that there's already liabilities in the Cyber Resilience Act, because the Cyber Resilience Act creates obligations, and if you don't meet the obligations, you may face a fine. So in business terms, this is one of your liabilities, and this is a valid use of that word in those contexts. However, that is not the meaning that is being used by the European Commission for discussions about product liability. The European Commission would say that the Cyber Resilience Act creates responsibility. It also creates fines, and fines would be seen by an accountant as being the opposite of an asset, and so it would maybe call a liability. But that is not the definition that we're using for discussion of product liability. The definition we are using is that the Product Liability Directive creates a right for a consumer to sue you. You may be the developer or a distributor, and that depends on the text. Also of interest is that the liability created in the Product Liability Directive is what's called strict liability or no-fault liability. So if there is damage caused by the software, you can't say, I didn't mean the software to do that, or it wasn't my intention, or I wasn't negligent. You can't use that as a defense. If the software caused damage, then liability may exist. So I want to discuss the actual status of the legislation. Similar to the Cyber Resilience Act, the text of the Product Liability Directive is now complete. It is still pending a rubber stamp from the Council. We expect this will happen and it will be a simple formality. Once that happens, then it will be published in the EU's official journal, and then 20 days after publication, it will enter into force. However, there is also a need for the member states, the individual countries in Europe, to then modify their laws to add in what's required by the Product Liability Directive. And so this is just a difference between a directive and a regulation. A regulation applies directly. A directive requires that the text is transposed into national law. So the member states will have 24 months then to put this into their national law, and at that stage, it will its obligations will or the liability that it creates will start being created. One difference with the CRA and the AI Act is that the Product Liability Directive does not require the development of standards. And so the Cyber Resilience Act requires 44 standards to be drafted, and this is going to continue for 3 years, and it will be a huge effort. There will also be guidelines published by the European Commission to explain some parts of the Cyber Resilience Act. However, for the Product Liability Directive, that's not the case. Another part of the legal context worth mentioning is that there is another proposed piece of legislation called the AI Liability Directive. And once again, like the Product Liability Directive and the Cyber Resilience Act, this was published in September 2022. So this started a very busy period for our policy teams. And this was worked on in the background, a little bit less than the other texts, until finally it was decided that this would not actually be necessary because the Product Liability Directive would cover most cases and the AI Act would cover the remaining cases. However, there is now a lot of talk that the AI Liability Directive will still be needed. And so this is, it's expected that there will be serious discussions about working on this after the summer when the new Parliament takes their seats. So this is something that we should be getting ready for. So then if we look at the text of the Product Liability Directive, the problem still is that it's difficult to say what the effect will be for our business communities and our software development communities. I won't go into details, partly because I'm not an expert in the details of product liability in general, but also because product liability will apply also to non-FOSS software. And so in that sense, we will be able to benefit from the work that non-FOSS companies put into their review and their thoughts about compliance. So this is something that will be clarified in many texts in the coming 2 years between now and when the when the liability starts to be created. What I will discuss quickly is the parts of the Product Liability Directive which are specific to free and open source software. So I showed you at the start the text which was in the original proposal from 2022 when I put it side to side with the text of the Cyber Resilience Act to show how similar they were, but also a little bit different. So in that original text, there was this exemption for free and open source software. There was also, since the original proposal, there has then been some parts added and mostly good parts. So we got a clarification added to say that developing or contributing to software does not constitute putting it on the market. And this is one of the conditions for liability to be created. So this should help reduce uncertainty for developers or contributors. We also got a clarification about open repositories, and this was done to help ensure that people who are hosting often very, very large quantities of free and open source software to ensure that they don't have to be concerned about being liable for the packages, sometimes tens of thousands of packages that they are hosting. There is, and there's also a clarification that the obligations and the liability will not be created for non-profit organizations. So once again, this is not as clear as maybe we would have liked, but it is it's a benefit, and hopefully we'll be able to use that. Finally, there is a clarification then in recital 15, and this may have been the people's interpretation in any case, but it is good to have these things written down in text so that people don't have to consult lawyers. This clarification says that if you develop software and publish it, the later commercial distribution by another entity will not cause your development or distribution to become a commercial distribution or an act that would cause liability to be created. So these are the benefits that we were able to get into the final text for free and open source software. However, there is a lot of dependence in all these texts on what does it mean for something to be in the course of commercial activity or not. On this, we don't have much clarity at the moment. Many of the problems come from product liability law existing in general for physical products and having a century of case law on how to apply it to physical products. And now this new directive has basically applied the old law to software situations. So the text itself is not so clear, and the reason they used words such as in the course of commercial activity is because these words and terms are defined in other parts of EU law. And so one of the main places for definitions of these terms is a thing called the New Legislative Framework. And there's a related item called the Blue Guide. And so these are texts which give definitions for certain types of regulation in the European Union. And they include definitions such as commercial and I believe the course of commercial activity. These texts also suffer from being written during a time when people had physical products in mind rather than software in mind. And so there is not much clarity in the texts currently. However, there is a plan for the European Union to review the new legislative framework, and this might include the Blue Guide, or the Blue Guide might be updated a little bit later. But this would then give us some clarity on what it means for software to be in the course of commercial activity, and will answer, hopefully, questions such as the effect of having ads on a website, or the effect of having related business activities, such as providing technical support for software or providing training for software. So this is something that we expect will also come up in the coming 12 months, although with a new parliament taking seat in August or September, it's difficult to make predictions about what their priorities will be. So with that, as mentioned at the start, it's not currently possible to say exactly what the PLD will create liability for, or how this will affect our development groups or our business ecosystem. We will be following in the next 24 months the publications from the software section as a whole, because the PLD will apply to to non-free, non-open software as well. So hopefully the analysis that they provide on the general concept of liability will be useful for us. And then we'll continue to think about what the exemptions mean and how to maximize our use of the exemptions, while also being aware that an exemption for non-commercial activity is not what we would have liked. We generally acknowledge that the commercial elements in the free and open source software ecosystem are often the entities that are employing the large majority of our developers. So while we worked on this directive, there was definitely no request from our side that the exemption would apply only to non-commercial. This is something we tried to avoid, but it was unavoidable in the end. So it is something we will continue to look into, what we can do to minimize liability or to create procedures for reacting to liability issues. And I suppose OpenChain may continue to have an interest in that over the coming months. But I hope what I was able to present is at least a useful base for understanding the context. And if there are questions, I believe it is time for those. Thank you.
Yes, we've got plenty of time to take questions. Thank you very much indeed, Kiran. And while our audience gathers their thoughts on this topic, I just want to say thank you for a comprehensive overview. Certainly, I did notice something you mentioned, that during the CRA discussions, because Product Liability Act was also running at the same time, there seemed to be some confusion or conflation between the two in some of the coverage around the internet. And I think this webinar will help to clear that up. Another item I wanted to raise as a question was, if people have additional questions on this, perhaps companies in jurisdictions like Japan or China, is it possible for them to reach out to OFE to discuss a little bit more?
I would say that we are not available to give expertise on individual responsibility of specific companies. We may not be able to answer questions. However, if people do express an interest, then that would show to us that it is worth following up and possibly organizing future events on this topic. So I'm interested to hear what people are concerned or interested in during the questions and answers, but also after the webinar, I can be contacted, or OFE can be contacted. And yeah, it would be more, so like OFE's role is often, rather than to be the experts on a specific topic, we try to help organize discussions around the topic. And so if we can help people who are interested in this topic get together with other people who may have the same questions or may be working on their own analysis, and if these can be put together, then we'll get more work done, and we'll be able to benefit the entire ecosystem in that sense. So we may do a coordination role on this, and with the hope of improving the general quality of discussion on the topic. But we also want to move on to many other policy files that we have to work on. So we won't be hanging around to become the Product Liability Directive organization in the long term.
Thank you. So Steve had a question, and it's a good one. So he said, and it's in the chat, there's an exemption for the use of free and open source software unless it's used in commercial activity. Is there a reasonable chance that the exemption might not apply for software under licenses rejected by the FSF or OSI because they don't meet the definition of free and open source software? So let's just do a proviso here. This is a speculative question, and no answer is legal advice or meant to be anything close to that. It's a speculative.
Yeah, so this comes back then to the question of interpretation. And when we see that the definitions used in the four laws that I presented on the screen, it suggests that they are, the European Commission and European institutions in general, are trying to make sure that their definition would be aligned with the definitions we've been using. So they've used the same structure, the same four freedoms approach that we've traditionally used, and in some cases they've used word for word exactly what exists on the FSF's website. So in this sense, it could be expected, yes, that if a license is rejected by FSF and or OSI, then this might also be how the European Commission would decide that this license and that software thus is not free and open source software and thus does not benefit from the exemption. The general topic of defining free and open source software is complicated. Some people may suggest that the European Union should simply say that they are following the interpretation of FSF or OSI, and this might be a very good solution. However, it may be unacceptable to some people from a legal point of view that the European Union would give an external entity power to interpret when the law of the European Union does or doesn't apply. So that could be a complicated way to resolve the problem. Another way would be maybe the European Union needs to develop a more detailed explanation of their interpretation, and so that may be a guide, and also maybe a set of accepted and rejected licenses with explanations of why they were accepted or rejected. So this would be the same thing as what Free Software Foundation has done, and I think OSI has something similar as well. And so that's something that's still to do. I don't know of any case law in the European Union that would help clarify how the EU interprets its own definitions of free and open source software. And so it's unclear at the moment. There are parts of the text which suggest that yes, the European Union will follow FSF and OSI's general practical application, but it's not confirmed. And some people are also concerned that the European Union would be too lax in their interpretation and may have a looser interpretation, which could allow companies which are clearly not involved in free or open source software to make use of the exemptions. And so the exemptions in the AI Act, they don't exist to try and ensure Facebook has a lighter regime, but some people are concerned that Facebook or other very, very large companies may be able to, or may try to avail of the exemption that exists for free and open source software. So the topic of interpretation is something it's still for the future, and we'll have to start thinking about how we can help them to reach a useful position that is compatible with our own interpretations. Because once again, we don't want a situation where some software is considered free and open source software in Europe, but it is not considered free and open source software in Japan or in other parts of the world. And that's kind of the next step. Like, it's already good that we have laws which are taking free and open source software into account, and then the next step will be to ensure that the definitions are applied in a sensible way.
Thank you, Kieran. There's a follow-up question. So we've got a bunch of questions in. We have one observation on the first, where mentioned we can have something at the Open Compliance Summit in Japan at the end of October on this topic, Catherine, Catherine, I'd love to. And if you would submit a talk, that would be fantastic. Perhaps we can look at having a panel or simple at the Open Compliance Summit. And I'm delighted to hear you'll be there, Catherine, and I hope others will be there too. But the follow-up question is from Steve again. And after that, I'll list the other questions. We've got one from Fukuchi-san and one from Sebastian. Steve's follow-up question. Do you think, again, speculative, that this situation might mean there's an incentive for open source developers to relicense their content or initially license it under licenses compatible with OSI FSF, even as a knee-jerk reaction? So again, just a speculative question.
This is quite an interesting question in the broader context of the other pieces of legislation, because so we have this exemption which applies to free and open source software, which is better than nothing. But we also have other texts in the Cyber Resilience Act, which also reduces the regulatory burden for software that is free and open source software. And then we even have some parts of the text that work together. For example, the AI Act says that there's an exemption for software which doesn't require third-party assessment. And then in the Cyber Resilience Act, we obtained a clarification that free and open source software does not require third-party assessment, even when it is in the special category of security software. So there are some parts of the different texts that actually work together. And I think it would be interesting if we find the time in the coming months to put these texts together and to write a document which would explain the regulatory benefits that now exist for people to publish their software as free and open source software. And so I think if a company was planning on keeping their source code secret and they had their business model organized around this, I think it might not be enough of an incentive for that company to reorganize their business model. However, I do think that if somebody was planning on publishing their software and it was under a license that was almost free, then they may decide that being just outside the scope is pointless, and that using a traditional free and open source license may be a better approach and may just make their life easier from a regulatory burden point of view. So yeah, I do think it will encourage some people to publish their software as free and open source software. But if we combine it with the other texts, I think we could possibly make a document that is quite convincing.
Now we've got a very interesting question from Fukuchi-san, and it's, should we consider examining liability or requirements for each regulation, such as CRA or the AI Act, as they may have different definitions? Or is it better to assume that there's a level of consensus?
Yeah, so this is certainly a question that we're going to be putting a lot of thought into collectively in the next 2 to 5 years. I think the definitions that I showed on the screen, it can be argued that they're so similar that they should have the same interpretation, or it can be argued that because they have tiny differences in each definition, maybe they have to be looked at separately. We will also possibly have to wait for some case law, which is very unfortunate, but we would have to wait and see when certain regulations and obligations apply and when they don't. So we're going to have to develop as a community, as a business ecosystem, we're going to have to develop business processes that take these risks into account and that try to avoid liability where possible, and at the very least where we can show good faith and that that we've done our best to be in compliance. But the question of do we have to look at each regulation separately? I think we have to draw separate conclusions, but anyone who studies one of them to become sufficiently expert to draw conclusions for one, that's probably also the person that you should ask to study the other ones, because there's a lot of overlap, and trying to understand one text will require the same study as trying to understand the other texts. So I think on a human level, there will be a lot of overlap between who's working on interpretation, but for the final results, the analysis, we'll have to take the separate texts into account.
That makes a lot of sense. We have another question from Sebastian. Do you believe that the criminal acts of authoring malicious software will potentially in any way absolve open source software redistributors of liability under the PLD? That is, if someone deliberately alters a vulnerable component in order to compromise something like the XC lib, to what extent does another party who happens to redistribute that hypothetically compromised open source remain liable? Will people be blamed if they redistribute compromised open source? I imagine the fundamental answer is yes.
Well, this is one of the benefits of what we managed to get into recital 15. And this is, let me see, oh, I just found it, that's fantastic. So in the final version of the Product Liability Directive, I fear the answer will be sometimes yes. And another way of explaining it is that in the supply chain, will every entity in the supply chain possibly have liability? And I fear that in some cases the answer will be yes. However, at least we got this recital 15 in, which clarifies that if the first entity in the supply chain is non-commercial, then a subsequent commercial entity may have liability, but will not cause the first entity to have liability. And so there's at least, in the case of XZlib, I don't remember whether the original developer was commercial or was being paid to work on the software. So I'd have to, well, one would have to check the details of a specific case. But I fear that yes, in some situations, yes, each entity in the supply chain may be liable. But if there are non-commercial entities, then they would be exempt at least. I say that, but this is also an element of the Product Liability Directive that is of general application to free and open source software, but also to non-free and open source software. So it's not one of the aspects that I've really dug into, and there are probably law firms that have published analysis of this type of question that would be able to give you a better answer than what I have done.
That's a good answer. Now we've got another one in the area. When EU member states make a directive into national laws, so it's from 4 to 36 months. How much variation do you think there will be between national laws on this, or will it be a straight inclusion? And is OFE involved in making the national laws, helping member states make national laws as similar as possible? So to what extent will the PLD just become verbatim in laws, and to what extent will national laws potentially change it around?
So in general, the way it works is that the directives will give the minimum that must be done in each member state. And so often member states will then be free to go further than the directive. This is called gold plating. But they won't be required, and sometimes it's not even allowed for the sake of harmonization. But in general, the Product Liability Directive will say the member state must provide for liability in this case, and then the member states will have to write their own law which does provide for liability in that case. And if the member state writes a law that's too narrow, they can be sued for I don't want to mention which branch of the court because I may get it incorrect, but there is a requirement that the member states cover all the obligations that are in the directive. So in that sense, there's not much leeway. In some other legal texts and some other directives, there has been more leeway, and I believe it was the EU Copyright Directive, for example. It had a list of exemptions that member states were allowed to optionally apply, and this was done because a lot of member states already had certain things that were allowed as fair use or fair dealing in their national law, and they didn't want these exemptions to be taken away. And so when they're drafting the EU Copyright Directive, they made a list of exemptions that member states could choose to apply when copying and transposing the text. However, in the PLD, I don't think there are such exceptions that can be elected by the member states. So there's not much margin for interpretation in a directive such as the PLD. In that sense, I don't have any plans. I don't think OFE we will be working with member states to implement the law in their national laws, simply because I don't think there's much room for us to improve people's situation by doing that. And there's a lot of other policy texts that we do have to work on. So probably not what I think. What's more likely to have an effect is the discussions in the next few years about when the PLD applies and about the definition of free and open source software. So these are things that will also define how the PLD will have a practical effect, probably more so than differences between national implementations.
Our final question today is Steve again. There's an exemption of open source unless it's, sorry, I do apologize. It's Steve's existing question, just a conversation occurred with comments that continued through. So we've actually covered all of the questions and answers. That's fantastic, Kieran. And we're at just about time. We're 4 minutes before close. So it's pretty much perfect. Sebastian is jumping in with a final question. Okay, and it's just about speed. He's asking, is it true that in theory, a member state could enact their transposition as soon as the 20-day period is up? So could a member state just enact this really fast if they felt?
Yes, that is true. And the reason it's true is because member states could also enact it today. They could have enacted it last year as well. So creating this type of liability, they don't need to wait for any EU regulation or directive to appear before they create product liability in their national law. And so, yes, they could apply it sooner than the deadline. I do know the timeline requires that they do implement it within 24 months. And it also, I think there's another previous law a previous EU directive which then ceases to apply at that 24-month point. So I am a little unsure what would happen if they implement early. Would there be any risk of complexity or incompatibilities between the law, which has not yet been retracted, and the new law which they brought in? But no, they are free to bring in a law earlier if they choose. As far as I know, I haven't found any formalities of which would stop that. I saw a comment there also asking about public domain and CC0. So public domain software is free and open source software, provided that the source code is available. So if you get a binary and you say it's under the public domain, then that wouldn't count as free and open source software because the recipients do not have neither the right nor the practical ability to study, modify redistributed modified versions. So public domain software, it should meet the definition yes, provided that source code is available. I would assume that that would be the only logical interpretation the European Union could adopt, that I see at least, but that's still up to them.
Well, thank you, Kiran, for another startlingly good webinar. Great reaction from the audience, lots of compliments pouring in. And thank you to the audience for both listening and engaging. We'll wrap up here. This will be published on our website shortly. And Kiran, I look forward to, in the future, doing more webinars with you, but this is the close of our 3 in a row schedule. Thank you so much for an epic amount of work. I will take it upon myself to distribute it far and wide. Well done.
And thanks a lot to you, Shane. It was a pleasure doing them.
Take care, all. Oh, it's always fun working together. It's been almost 20 years now. Never gets old. Take care, everyone. Have a beautiful day.